Hello, madam. Today I would like present about one of constitutional doctrines about supremacy of the constitution. Background: according to Article 4, subsection 1 of the Federal Constitution is the supreme law of the Federation, and any law passed after Merdeka Day which is inconsistent with this constitution shall to the extent the inconsistency be void. Looking at the provision of Article 3, subsection 1 and 2 above, there is no doubt in coming to a conclusion that the Trade Commission was dedicated to the idea of having the Malaysian Constitution built on the noble foundation of the doctrine of rule of law. Moreover, since Article 4 subsection 1 came as a substitute for the Commission draft Article 3, it may be rightly concluded that in terms addressing the status of the rule of law beneath the federal constitution, the starting point would always be by the way of making a direct reference to the provision provided in Article 4. This peculiar line of reasoning is required due to the fact that the original purpose of Article 4 is evidently to set up the Constitution as the foundation of rule of law. Futures Article 4 subsection 1 refers only to post-Merdeka law. Pre-Merdeka laws are dealt with in Article 162. Yet, under Article 4 subsection 1, any post-Merdeka law which is inconsistent with the federal constitution shall be declared void. Under Article 162 subsection CE, any pre-Merdeka which is inconsistent with the federal constitution shall be continued with necessary modification to render it consistent with federal constitution. It would seem to be that Article 4 subsection 1, which is viewed as the basis of the doctrine of the rule of law, could be said to be diluted by some features in the constitution itself, such as the power of amendments vested on parliament in regard of the constitution under article 159 and the law-making power confided in the executive, one whose advice the young di Pertuan Agong is bound to act under article 150. Article 135 provided further that this clause shall not apply to a case where a member of any of the services mentioned in this clause is dismissed or reduced in rank by an authority in pursuance of a power delegated to it by a commission to which this part applies, and this proviso shall be deemed to have been an integral part of this clause as from Merdeka Day. According to the case of Surinder Singh Kanda against the government of the Federation of Malaya on 1962, it was contended that the dismissal of an inspector of police was void on the ground that it was contrary to Article 135, subsection 1 of the Constitution. Lord Denning applied Article 162, subsection C, and stated the in the conflict between the exciting law and the constitution must prevail and the court must apply the exciting law with such modification as may be necessary to bring it into accord with the constitution. In another case of Chia Kinsey against the Mantri Bazar state of Selangor on 1958, the first case reported which directly involved the interpretation of the Constitution, the High Court held that a Slango enactment passed before Merdeka Day must be applied in its original form, even though such a law could not have been passed after Merdeka Day. This view, this view has now been held to be wrong. The court held that such the fundamentally liberty envisaged under the Constitution was intended to be merely declaratory of exciting laws and not mandatory right to be defended by counsel presupposes a right to be heard. The respondent was under no obligation to hold an inquiry before the applicant had no right to be heard and he could not have the right to be defended by counsel. Thank you.